natural resources. I teach one of the courses that I regularly teach is conservation of natural resources. So I'm a little more up on natural resource stuff than what this textbook provides. And I can tell you that this chapter is really, really, really sparse. It doesn't cover that much stuff. I actually have a lot more in my notes to talk about, but I've tried to skip some of that. So anyway, and hopefully you can see this. But to begin with, we'll start off talking about how water law exists in North America. My notes are here trying to describe the two types of water rights that we have in North America. The first kind of water rights are those that were brought over by the Northwest Europeans, the English primarily. And the English brought what's just referred to as a riparian system of water rights. And a riparian system is associated with an area that doesn't have any real need for water except for things like transportation. Laws that prevent people from damming rivers up and stopping the flow of commerce. So we really don't need to worry too much about riparian water law because there's not much to it. It's not associated with irrigation. Native American water law is entirely associated with the need for irrigation water or industrial use of water. So, and also most Indian country, as you know, is west of the Mississippi River, and a lot of it's west of the Great Plains in the Mountain West. That is where, in the Mountain West, Spanish law prevailed earlier. And even though the United States often incorporated local versions of laws, like when the United States purchased Louisiana, we incorporated Louisiana's French, or actually a Spanish-based legal system that required, it's different in Louisiana. If you, in the case of a will, for example, there's a requirement that you have to leave so much for your kids. Anyway, the Spanish appropriative water law system is one in which it's oriented towards using water as a finite resource. And it is referred to as the appropriative system, or the system of prior appropriation. It comes from Spanish law that also has connections to Roman law. And the Romans were very good at building aqueducts and moving water, and for various reasons. Prior appropriation has impacts on different types of land use, including mining, but primarily ranching and irrigated agriculture. Irrigated agriculture is what we're really concerned with. The appropriative system is basically what we're going to be talking about. So American Indian tribal water rights are essentially appropriative water rights. They're working within an appropriative system. In the appropriative system, rights to the water belong to the first user or claimant. And that's the person who receives an appropriation. So an appropriation is a water right, kind of like a mineral right, based on when one made the claim. So everything has to do with the timing of the claim. Therefore, the term prior appropriation. If someone has a prior appropriation, they have a higher degree of right. They have a greater right to water than you do. And if a claimant is another facet of the appropriative system is a requirement that what most people just call it the use it or lose it doctrine. Use it or lose it. So it's kind of like university budgets. Use it or lose it, or any sort of bureaucratic budget. In this case, if you're not a user of the water, like for irrigation purposes, then you don't have a right to it, even if you have a prior appropriate right. So if a claimant, as an example, if a claimant has a prior right and uses that, then any later appropriator cannot take away his right to the water. And I'm just using his as expedient. So that person is subject only to the demands of any appropriators before him. And generally, and that can be upstream or downstream, right? So, or it can be it's only downstream. So he's subject to the demands of any appropriators that preceded him. When there's a drought, like maybe now, when there's a drought, then the latest appropriator loses out. That's, you know, the person that has the latest, most recent appropriations. They're the ones who don't have the rights to the water. The oldest water rights are going to pretty much be insured of getting water. So the older the claim, the more secure the claim during a drought. Now, okay, so that's enough about that. Water law, like most natural resources, are in the United States, in the US federal system. Natural resources are essentially the domain of the states. Now, there are some exceptions to that. Marine resources, of course, outside of the boundaries, mostly outside of the boundaries of the states, are mostly managed by the federal government, National Oceanic and Atmospheric Administration, NOAA. But most other terrestrial natural resources, whether they're above ground or below ground, typically are managed by the states, especially if those resources are coming from privately held fee land. Okay. Only federal land, like national forests, national grasslands, those resources from those federal lands, Bureau of Land, or so-called public domain lands, those are managed by the federal government. States don't have to deal with those. So with regard to Indian country, federal land, we're talking mostly about the use of tribal and federal jurisdiction, okay? So there is an issue here. States will typically want to extend their jurisdictions into Indian country for various reasons of resource management. And we'll get into some examples. The most important water law that affects Indian country is the most important case that sort of initiated tribal water rights is Winters versus United States from 1908. It was a Supreme Court case involving the Fort Belknap Reservation in Montana. And this was it's a landmark case for a number of reasons. Number one, it was actually a victory for the tribe. In 1908, that was something that, that was pretty significant. The judge who, and this is this is a Supreme Court case. So the justices that were responsible for this we'll get into a little bit later. The one particular justice, the Chief Justice at the time, became known for, utilizing the Indian canons of construction to interpret things, right? And the Winters case was one of those. And it was kind of an interesting situation. The reservation itself was created in 1888 by an executive, or by an agreement, an official agreement, not a treaty. The boundary included the Milk River, but there was no mention of water use in the river, or water use from the river. And I can actually show you maybe a little example here. Hopefully you can kind of see this. You're looking at, zoom out a little bit so you can kind of see where we are. There's Montana. Zoom in I'll turn the Indian reservations on. This is the Fort Belknap Reservation right there. So we'll zoom into that. That shaded area is the reservation area. And you can see the Milk River up here. See if I can switch to some imagery here so you can see it a little bit better. Now, this river, of course, is going through fairly dry land. If we have a look at the country around the reservation, let's go this way. Here, what I'm doing is we're using Google Earth to kind of have a look at that same location. Okay. So the river valley is kind of obvious, right? Ever wonder what this actually looks like in person? Well, of course, we can do that now, right? Now, this is where the agency is. And if we go to Google Street View, you can drive around, have a look at the place. Takes us through different seasons and stuff like that. Whoops. Maybe I should get my bearings a little bit better on that. Okay. So on the left is, maybe on the right. What would that be? It's like a casino. Right. So anyway, that's the landscape around the place. Let's go back to where we were. So if we look at this boundary, then the Milk River is the boundary, and not long after the reservation was created, not long after that, non-Indian settlers came in and started diverting the river water into irrigation canals to use the water for agriculture. And this, that was after the creation of the reservation, but before the tribe was actually having need for the water. The court found no point in hearing whether the Indians were using the water, since the existence of the reservation implied farming, and farming implied water rights, at least in this part of the world. That's the important part. So, let's see, the judge in the case. Anybody remember what the name of the justice was?
McKenna.
McKenna, yeah, thanks. Justice Joseph McKenna. And you remember him from other things, right? From fishing rights, I think. Well, anyway, so McKenna was the justice, and I believe he wrote this opinion. And what's significant about the opinion, other than using the canons of construction, is that he pretty much defined a reservation as a place that is, it's established for and reserved for the exclusive use of an Indian tribe. And by creating a reservation, the government was implying that it wished for the tribe to settle down, right? Not be nomadic, to take up agriculture. And in 1908, even by 1908, it was assumed that agriculture would be, the way of life for people on a reservation. So that meant that any reservation automatically implied the rights for the natural resources to be used by the tribal people, by the tribe. And they had very strong rights because of this Winters decision in 1908. But as you may recall from the reading, it was not to last. So between 1908 and 1963, when another important case was decided, Winters' rights pretty much were ignored by private interests, as well as the government, states and the federal government. Not long after, the Winters decision, we have the Great Depression. We have, a little farther south, the Dust Bowl. But during the 1930s, during the New Deal, one of the most significant, make work projects, development projects that Roosevelt and his New Dealers got into were constructing dams. First with the Tennessee Valley Authority, and later with other authorities, primarily through the United States Army Corps of Engineers after World War II. So the federal government went pretty much into the business of damming big rivers throughout the West, especially the West, and that would include the Great Plains to some degree. But when the federal government was, okay, so let me try to interpret what you're reading here. Despite the 1908 ruling, the Indian water rights that would apply to all tribes were essentially run over roughshod by all these different interests. The federal government spent really billions of dollars developing those Western dams and building dams, not only building dams, sometimes creating whole towns of workers, sort of company towns in the West. And so for about 70, maybe even you could probably say 80 years after 1908, the United States Army Corps of Engineers, USACE, built dams for various purposes. These were mostly for flood control in our part of the country, in the Great Plains and farther east, but and also power generation and navigation. In the West, mostly it was for irrigation and power generation. And the federal courts pretty much just, didn't pay any attention to, and tribes they really didn't raise challenges to the federal government in doing all this. It was considered, part of the development of the country for decades and decades. Here in Stillwater, for example, our drinking water here in Stillwater actually comes from Ponca City via a pipeline from Kaw Lake. Kaw Dam was completed when my sister and I lived in Ponca City, before, I guess, about, I'm not sure exactly when it was finished, but I know it was being constructed in the late 60s. And I know that only because my sister used to say that she always liked driving over a Caw Dam, because she would say, "We're going to Caw Dam." And she would, that was when she was 6 years old. She thought that was kind of cool. Anyway, that's one later dam. I think was probably open in the late 70s or early 70s. And that's sort of the end of the dam period. A few others, the McClellan-Kerr Arkansas River Navigation System that made Catoosa the westernmost port within the Mississippi River Intracoastal Waterway. All of that was done in the 60s. All of those dams in eastern Oklahoma, mostly built in the 60s. Of course, some of them, like Grand Lake, were earlier. But so anyway, their winners' rights kind of just go dormant. Then what happens in 1963? Actually, that's the wrong case. Let's go to this one. And in 1963, we have another landmark case, a really long, drawn-out case called Arizona versus California. And you don't want to even look at the oral arguments on this one, because there's multiple arguments and re-arguments for this case. It was in the courts forever. But this was a case that involved the utilization of the Colorado River water. And the Colorado, as you know, is really heavily utilized in Arizona and California, Southern California. And it also involved the water rights of tribes on the Colorado River and, accessible to the Colorado River, whose reservations had been established by either federal statute, a congressional creation, or an executive order. Arizona versus California sort of revived Winters, and it held that any reservation established would imply that the government intended farming, and that, of course, by nature implied water rights necessary to allow the land to support the people living on the reservation. Okay, so we're going to talk a lot about this, but as far as prior appropriation doctrine goes, the rights to the water were reserved as of the establishment of the reservation. So what we're looking at now is, when was a reservation established, okay, in order to have that prior appropriation over other users. And there was also an issue about, what do the Indian tribes really need, okay, in this legislation. So a very small population on a reservation shouldn't have to have a whole lot of water, or all the water they could possibly use. So the question was, how much water can be fairly allocated to an Indian reservation where agriculture is implied with the reservation, right? How do you calculate how much water a tribe can legitimately demand as their right, okay? Because the water is not going to stop there. It's going to be used by agricultural interests elsewhere. Where does the Colorado River ultimately wind up? Where does it exit? 200 years ago, it would exit. It had its mouth in the Sea of Cortez, or the Gulf of California, whatever you want to call it. But most of the water today is utilized before it ever gets to the Sea of Cortez. So the Supreme Court basically, refuse the argument that tribes had access to all the water. They had rights to all the water. And they came up with a term and what's basically a metric for calculating what a reservation can be allocated. This is something called practicably irrigable acreage. Try saying that 5 times real fast. Practicably irrigable acreage. That is essentially how much acreage on a reservation could be irrigated if you did irrigate it. That's what they are owed. Okay, that's what the tribe has a valid claim to. The practicably irrigable acreage. If your reservation is made up of mountainous terrain, then you're not going to be able to utilize it for irrigation, right? All right, now you can see that. So practicably irrigable acreage, what does that mean? The PIA, as we might call it, allows a fixed calculation of future water needs. Tribes may use water, they may use water allocation for any purpose. This is what Arizona versus California decided, that tribes can use the water for any purpose. Now, it's important to recall that by allocating water, what are these legal scholars not thinking about? Well, they're how do you decide what's practicably irrigable? Well, the assumption is that all of the tribe will, has this one reservation that they are going to make their living from forever. All right, that's the assumption. Now, of course, when reservations were created, what did the government, what did Congress, what did the American people assume? That was a question.
They'd assimilate.
Okay, that they're going to assimilate, or what else?
Die off.
Going to die off. They're going to disappear. So the reservations were never created to be permanent, right? But that wasn't really specified, because according to the government, it was their land for as long as the waters flow, the wind blows and the waters flow. So here we have sort of the reality of what a reservation really is sort of hitting home. So what this did is it kind of opened up the sort of thinking about, all right, well, if a reservation can claim as much water as would be required to irrigate all of the possibly irrigable land within a reservation, that's a lot of water, probably, all right? But that's the assumption that agriculture can be the only use for the water. And later on, let's see, I don't think it was this one. Okay, this is some more on the Wind River, or this is not the Fort Belknap reservation. This is different. But practicably irrigable acreage might mean the use of water for other things, right? You can't assume that an Indian tribe is going to be developing if their population's growing, but they can only grow food, on the reservation. And the idea is to be self-sufficient. So location is very, very important with respect to the claim for water rights. Okay, the size of the reservation is, my note here is that location makes much of these possibilities very impractical and virtually kills any chance of attracting outside investment, right? So you can use the water for maybe creating a reservoir for a power plant. You could use it for refining grains or sugar. You can use it for production of livestock, poultry, cattle, beef, hogs, whatever. Use it for manufacturing dog food and cat food. All of these actually use a lot of water. They're industrial water users. And the only, most of us think of water use as, watering our lawns or, taking a shower or flushing the toilet, drinking water. The vast proportion of water use within the United States and, developed countries in general, the vast amount of water is going toward, number one, agriculture. Okay. For example, Texas County, Oklahoma, which is our number one irrigation county in the state, which is out the middle, it's the middle county in the Panhandle. That county uses more water for irrigation every day than does New York City. Okay. That's a lot of water. And so agriculture in general uses a whole lot of water. After agriculture comes an industry. Industry typically uses a lot of water as well, depending on the type of industry. Well, in places like the reservations we're looking at, the Western reservations often have timber, which if you're producing paper, that's going to require a lot of water. They're also in mining countries, especially Montana, Wyoming. Mining is a big user of water as well, depending on the type of mining. So practicably irrigable acreage is just a fixed metric for determining the quantity of water that an Indian tribe has a right to claim on a reservation. The example of the Wind River Reservation in Wyoming, and I think fairly old reservation established in 1868. I think it was part of the Second Treaty of Fort Laramie. You've read about it being diminished. There was a session in 1906 that diminished it. But anyway, here's an example of how states will frequently encroach upon tribal jurisdiction. The Wyoming Supreme Court interpreted a reservation's purpose was only agriculture, and that water rights included only practicably irrigable acreage. And like other states, Wyoming, presumed that it had jurisdiction over water use, groundwater, as well as surface water rights. So the Supreme Court found that the purpose of the reservation to be not limited to agriculture, but just supporting the tribe in general. Mining had been involved or had been included as one possible use for water by reservation tribes. And on the Wind River Reservation, remember that was the Arapaho and Shoshone. Remember that? So the Arapahoes outgrew the Shoshones, but you got 40,000 people. 40,000 tribal members making up 29% of the total reservation. So what the courts did were, the courts ruled that you can't just assume that a tribe is only going to be a farming tribe, that other uses, could be claimed. I mean, uses for other things than agriculture, tribes have the ability to claim that. So in general, over time, over the 20th century, Joseph McKenna rules in Winters versus the United States that Indian reservations, by their very existence, imply water resources, and basically Indian tribes have strong water rights. although those were pretty much ignored for half a century or more. In 1963, with Arizona versus California, we have a new finding that that tribes not only have the rights to the water, but they can claim enormous amounts of water. So very, very strong rights. Over the course of the 20th century, later cases after 1963, would continue to uphold tribal water rights. So as far as natural resources go, tribes generally have very strong rights to the water near their Indian country. Another example, well, actually, these are several examples of water rights of tribes winning water rights. One of the more interesting one, and I think it was Nevada versus United States, or it may have been Pyramid Lake Paiute tribe versus Nevada. I think it was that one. They utilized the water. They claimed water to reclaim a trout fishery, basically to make a river that had been neglected, sort of to reclaim for conservation purposes a river, and they made it into a spectacular trout fishery that attracts tourists and tourism. That idea of practicably irrigable acreage ignores the possibility for reservation populations to increase, for economic development to expand beyond farming, or to progress beyond farming. And this became known as the so-called homeland purpose, okay? Homeland purpose of the reservation. So because of a ruling that identified a reservation intentionally was a permanent home and abiding place of a tribe, then this homeland purpose expands the tribe's rights to water. Essentially, they have pretty much all they want, okay? They don't have to use it necessarily. Here's the Pyramid Lake Paiute tribe example. In northwestern Nevada around Reno, up near Lake Tahoe, rather small population, 1,600 people, 742 square miles, along the Truckee River. That is a large amount of the reservation is water. So that reservation was really old, established in 1859 by an executive order, and the tribe was moved there in 1859, but the reservation wasn't made formal until 1874. So that's what we're looking at here. But the tribe used its 1859 presence, sort of an earlier stage, to divert water to Pyramid Lake, which saved the lake from agricultural users that were diverting water from its source, the Truckee River. So now the lake is healthy and supports this cutthroat trout fishery, which I was trying to refer to earlier. Winter's rights refer to Indian rights or tribal water rights when there's a reservation, okay? So it's only referring to trust land, but a reservation is a reservation, right? We've got big reservations in Oklahoma now. And despite the fact that there is not a lot of trust land within those reservations, there's still reservations, right? So this McGirt opens up a lot of sort of new questions about what tribes can do to regulate water use, or to claim water use, or to sell water, all sorts of things. So the important terms for this chapter, these are taken from the textbook. Joseph McKenna, Winters versus United States, 1908. Big victory for Indian tribal sovereignty and claims to water. Used the canons of construction and the equal footing doctrine. You know what that refers to? Okay, that means that any state that is created later comes in with the same footing, the same authority of any other state, going back to the original 13 states. So how does the equal footing doctrine fit in with water rights? It was used within the Winters argument, wasn't it? The equal footing doctrine, this is on page 555, equal footing doctrine has been a recurring argument in federal Indian law litigation and still occasionally makes appearances in contemporary cases. In general, states have a significant amount of authority to regulate the natural resources within their borders. Okay, so the equal footing doctrine pretty much places states at the forefront of natural resource regulation, but Indian tribes have have an increasing sort of say in resource regulation, and that the Clean Air Act, and as you recall, the Clean Water Act, or the National Environmental Protection Act recognized Indian tribes as equals of states. So reservation land can now be, at least in the eyes of the Environmental Protection Agency, reservations are kind of equal to states in terms of allocating and regulating resources, which means that reservation lands under the authority of a tribe, say Muskogee Creek Nation, can have higher standards for air quality and higher standards for water quality than the state of Oklahoma. It can't have lower standards. It can't make standards any lower because, of course, the state of Oklahoma is going to have much lower standards than the actual federal, they're probably going to have standards that, are at the very minimum of what federal law requires. All right, I mentioned here that Winters' rights are in some ways a double-edged sword. Assuming you've read this, I'm not going to assume you read this. Again, on page 555, your author says, the decision in Winters, and thus the doctrine itself, is also characteristic of the troubling foundations for many of the victories for tribal nations at the Supreme Court, particularly the few that occurred in the allotment era. It is a double-edged sword that rests upon certain notions about the capacities of Native peoples and the obligations of the federal government. Meaning that allotment is in play here. The reservation implied agriculture, and of course there's dependency. So a lot of the rulings that tribes win are often based on the dependency theory, on this sense of dependency that comes out of John Marshall. All right, we've talked about Arizona versus California. That finding brought us the term practicably irrigable acreage. It also amended the Clean Air Act's treatment of tribes as states, so we talked about that. And there's another issue called the Chevron decision, and you'll read about that. Has nothing to do with the oil company, but that's where it came from. Deference is, or the Chevron deference doctrine is discussed on page.
I was going to say it's on 561.
561 with regard to the Arizona Public Service Company versus EPA. So in applying the Chevron doctrine, the question becomes, is the statute or regulation clear? And if not, then is agency interpretation reasonable? So when a party wants to challenge an agency's interpretation of a statute or its regulations in a lawsuit, the court will apply the Chevron doctrine. I'm not going to ask you about that. All right, let's move on to hunting and fishing rights. And with that, we go to New Mexico versus Mescalero Apache tribe. This is one of my favorite cases. And what's going on here is the Mescalero Apache tribe, all right, had this, and if you listen to one, if you want to listen to this, I don't know, is anybody using this for their paper by chance? All right. It's a very interesting case that was argued by, I mean, a really ace of an attorney by the name of Thomas Dunnigan. Thomas Dunnigan died in 2011. He had a bachelor's degree from Stanford. He had a law degree from Georgetown. He had an MPA from Harvard. That's a master's of political, I don't know, or public administration, master's of public administration from Harvard. And then he studied politics at Oxford. This guy, if you listen to one of those Supreme Court cases, listen to this one. Listen to New Mexico versus Mescalero Apache tribe. Dunnigan is arguing for the state of New Mexico, for the the petitioner in this case. This was a 1983 case that involved the application of, it's similar to what we've been looking at. It has to do with jurisdiction of a state over non-Indians within Indian country. But in this case, it's not criminal jurisdiction, it's regulatory jurisdiction. So you remember in cases that you were tested over, I was just grading some of these questions. What was it? Nevada versus Hicks. Remember that? What did Nevada versus Hicks decide? Actually, what did Montana versus United States decide? Or what was the Montana test all about?
Wasn't it that there were exceptions to the general rule that tribes don't have the civil or regulatory authority over non-Indians? Exactly. So, that's the general rule in the Montana.
Yeah, the premise, the basic premise is Indian tribes don't have any sort of regulatory or jurisdiction over non-Indians within Indian country, okay? Unless, of course, Congress has delivered that, delivered that authority to the tribe, or if the two-part Montana test applies, one of those two factors in the Montana test apply. Number one being the existence of a consensual business relationship between the non-Indian and the tribe or member of the tribe on Indian land, or if the non-Indian entity, whether it's a business or an individual person, poses poses jeopardy to the carrying out or the functioning of the tribal government, or the safety and welfare and health of the tribal people on the reservation. If that's the case, then you have one of those are, the two Montana exceptions, right? So what did Nevada versus Hicks find? Remember that Montana versus United States left a question open, because what was actually Montana versus United States asked the question about, tribal jurisdiction over non-Indians within a reservation. But the example of Montana involved non-Indians acting on non-Indian fee land within a reservation, right? So Montana found that, okay, tribes only have jurisdiction if they have those two exceptions. Nevada versus Hicks, 20 years later, determined that non-Indian interference or non-Indian tribal court jurisdiction over non-Indians on tribal land, on trust land within a reservation, is really no different. Okay, it's a mouthful. That the tribes were assuming, okay, well, if you have white people acting badly on trust land within a reservation, well, maybe the tribal courts have jurisdiction over them. Well, that's true with domestic violence cases and the Violence Against Women Act reauthorization, right? So that's the only exception where tribes sort of automatically have jurisdiction over non-Indians within a reservation, as if they are involved in domestic violence. So generally white man or non-Indian man and Indian woman. But the court determined, well, if it's on trust land, that's one thing that might change the outcome of the Montana test, but the Montana test still is required. There's no automatic. And the reasoning for that, I didn't really get into it, either in your responses on your exams or whatever. But the reasoning that Anton Scalia gave was that that tribal courts, unlike state courts or federal courts, are not courts of general jurisdiction. Okay, they're not geographically defined. I mean, tribal courts' jurisdiction are not defined by boundaries. They're defined by boundaries plus people plus identity, right? Okay, so why am I getting into this? Because in the case of Nevada versus Hicks, not so much Nevada versus Hicks, but Montana versus United States, there's tribal jurisdiction and then there is federal jurisdiction, right? So tribal and federal jurisdiction exist in the same place. What do we call that? Concurrent jurisdiction, all right? So concurrent jurisdiction can exist. And so this case, New Mexico versus Mescalero Apache tribe, is another example of concurrent jurisdiction, except in this case, concurrent jurisdiction between the state of New Mexico and the Mescalero Apache tribe. So what did the Mescalero Apaches do to provoke a lawsuit by the state of New Mexico? They imported they imported a population of elk, I think, from Yellowstone National Park, and they got a breeding population of elk going within their reservation. All right. Let's look at their reservation. It's an odd looking thing. But you'll notice that if we zoom out here, see where it is. It's in the, actually I met a guy from this area one time at a conference, an Apache guy, and they manage, within their reservation, they manage timber, but they also have, you notice that this is a mountainous area and very, very remote. So they created essentially they got an elk population started, and they managed that elk population with, professional game managers and such for years. And then they opened it up for trophy hunts. And essentially they were running what they called package hunts. And that is, hunters would, travel to, they would stay in this lodge on the reservation. They would have a guide. They would go out, they would shoot a bull elk, big trophy thing. The tribe then would, process it for them and send it, FedEx it to, home. And basically it was a big all-inclusive package deal that made the reservation, made the tribe a buku of money, or at least it had the potential to make the tribe fairly wealthy. So how did the state of New Mexico get involved? Well, the tribe was essentially having these hunts, and then they charged their own license fee to the hunters, because all the hunt was going on within the reservation boundaries. So the tribe made the assumption that, well, we have this land, and the natural resources are part of the land, and we're supposed to make a living off the land. So this is a pretty smart way to utilize our reservation land. It's all, mostly wilderness. It's not agricultural. Let's do, tourism and hunting tourism, highbrow hunts. And charge these, these New Yorkers tens of thousands of dollars to come do this. And there were others successful. And the state of New Mexico then came in and required or the state of New Mexico claimed concurrent jurisdiction over the reservation, with the argument that non-Indians hunting elk within Indian country are still under the jurisdiction of the state as well as the Indian tribe. So the state was upset because they were not getting out-of-state hunting license fees from these people coming into the Mescalero Apache tribe or reservation. Following me? Okay. So if you hunt or you fish in the state of Oklahoma, you have to have a state hunting or fishing license, right? You pay that fee, and the operation of the Oklahoma Department of Wildlife, Oklahoma Department of Wildlife Conservation runs many of its programs based on licensing fees. Okay, it doesn't get a huge allocation from the state. If it gets any, it gets some from the federal government. But it really relies on licensing fees as well as fines, but mostly licensing fees. So the state's upset because the tribe is not charging these state licensing fees, they're charging their own licensing fees. So that's what this is all about. The state contends that any non-Indian hunter needs to pay the state, the out-of-state license is pretty steep. There are a lot of states like South Dakota, Nebraska, Iowa. They make a lot of money from hunters that come from out of state because the out of state licenses are always really, really high. Like 10 times higher than the in-state license, if not more. Kind of like tuition. College tuition's like that, right? And the excuse is that with college tuition, well, if you're not paying state income taxes, then you're owing us more money. Which is largely bogus, but anyway, so the out-of-state fees are not getting paid. What's the tribe argue?
Did the tribe argue that they have sole right over the hunting and fishing on the reservation?
Yeah. So, and the tribe's defending itself because the last thing it wants to do is raise the price of the hunt further. But even more, the tribe feels that they're the ones that incurred the investment in developing this tourism industry. It wasn't cheap. They had to hire a lot of people. They employ a lot of their own people to do this. They were actually doing a fantastic job, according to the outside observers. That they had sort of a premier game management policy and program going, but the state wanted to assert itself. So they also had some disagreements on regulations. So on page 568, you'll read in the opinion that numerous conflicts exist between state and tribal hunting regulations. For instance, tribal seasons and bag limits for both hunting and fishing often do not coincide with those imposed by the state. Now, in the case of the elk hunts, I don't think that was the case. It certainly could be the case, say, if, one of the biggest industries in South Dakota, other than agriculture, is out-of-state pheasant hunting. Pheasant hunters come from all over to go shoot pheasants in November or December or whatever it is. And, there are a lot of tribes that could do the same thing for, for tribal land. And I don't know if they do or not. I would assume they probably are doing this for pheasant hunters, but of course, a lot of the pheasant hunting, that's all in corn and corn land, and there's not a lot of that on the reservation. So, question: can the state restrict the tribe's regulations to be equivalent to that of the state's? The state claims concurrent jurisdiction over non-tribal members, so state regulations apply to non-members on tribal land. So is this the state overreaching? Is this the state encroaching upon the sovereignty of the tribe? Not only that, but the federal government supported the tribes in developing this elk population. So you had the federal aid coming in, or at least they were making use of this, and there are also the tribe made the argument that that this healthy elk population doesn't look for signs that say you're leaving the reservation. So the expanding elk populations actually, going into off the reservation, and that's improving the hunting that is totally regulated by the state. So why did New Mexico even? Well, okay. What became of this lawsuit? Despite the fact that that hotshot lawyer that I was mentioning argued this case incredibly well, Thomas Dunnigan, he argued this case really, really well, but the Supreme Court found for the tribe. New Mexico lost. Okay, so why in the world did New Mexico even bring this lawsuit? In the opinion, which was written by, I think, Scalia, no, Thurgood Marshall, this is way back 1983. Thurgood Marshall says that New Mexico does not contribute in any way, or New Mexico does not contribute in any significant respect to the maintenance of these resources and can point to no other governmental functions it provides in connection with hunting and fishing on the reservation by non-members that would justify the assertion of its authority. So it's a really subjective call, I think, but the court found in favor of the tribe, and New Mexico lost this case. So this is one example of what I want to convey here is that, like water rights, hunting and fishing rights, and you've read already about treaty rights a lot. Hunting and fishing rights, tribal hunting and fishing rights, especially if they are founded in a treaty, are very, very, very strong. Tribal hunting and fishing rights are very, very strong. In fact, they can go dormant for a period of time and then be revived. Remember PL 280 and how PL 280 extended jurisdiction into Indian country? PL 280 didn't put a dent in hunting and fishing rights among tribes, even tribes that are terminated. A tribe that is terminated loses its relationship with the federal government, will even retain hunting and fishing rights that are made by treaty. That sounds counterintuitive, I know, but it's the case. Now, you've also read about, actually, your textbook doesn't cover it very well, but let me go back to this, natural resources.
I have kind of a general broad question.
Excellent.
Hunting and fishing rights are, more protected or stronger, basically going off of what you just said. Is there any reason? Is there anything specific that has led to that trend?
I think that you remember the phrase associated with Washington versus, or United States versus Washington, I believe it was. The United States versus Washington involved treaty fishing rights. And remember, that was the example, or maybe it was United States versus Winans. In fact, I think I have something here with Winans. No, I don't. United States versus Winans, the government pulled from the treaty the terminology or the phrase using the fishing grounds in something like in the usual Indian way. Okay, that kind of phraseology is basically saying that, native peoples, if anything, were gaining, they were living off the land from hunting and fishing. We know that. Now, of course, they were also most were agriculturalists, right? Most were agriculturalists, but there's a strong tradition in the United States, even in the law, that native peoples were nomadic. Okay, that they were always nomadic. In fact, I was just editing some stuff, some earlier notes that I didn't include here, but that was one of the stereotypes that always popped up in when states would try to argue against in treaties of cession and stuff like this. They would often sort of denigrate the tribe by saying, well, these are just nomadic peoples. They live off the land. And that goes way back to pre-United States, culture. Native peoples were always portrayed as savage, nomadic people, right? We know that. Has anybody ever read the book, The White Man's Indian? One of my very favorite books. Very, very favorite. This is if you get a chance sometime, pick up a copy of this. This is a wonderful book. And I don't know what edition. This was the probably 1978. Okay, so it's not a new book. But it's a fantastic book, and it's all about how American culture created this imagery of Native American people, okay, and all the stereotypes that go with it. But what I'm getting at is that ideology that Native peoples live off the land, and they mostly live off the land through hunting and fishing. That's generally considered, central to their existence, even before reservations were started. The idea of reservations being agricultural and sedentary lifestyles. But even before reservations, the assumption was the use of the land. Remember, that's what Marshall was all about. He was saying that Indian title is a possessory right, the right to occupy and to utilize the land, but you can't sell it, right? And that occupancy utilization meaning was pretty much hunting and fishing, getting all of your material goods from that land. So I don't know if that answered your question or not, Micah, but that's basically where that comes from. Now, within the New Mexico versus Mescalero Apache example, that case, there were a couple of other terms that we need to keep in mind, and that is the term federal preemption and the infringement test. The infringement test is covered in Chapter 10. If you want to go back to that. But the term federal preemption is basically the federal trust responsibility preempting the ability of a state to, it happens with taxation, and here it's with regulation. So RECOT says that recognizing the federal government's role in these matters, sometimes courts will decide that federal actions have preempted otherwise valid state efforts. Put another way, if the goals, resources, and actions of the federal government in a particular matter are both significant and contrary to the efforts of the state, then the federal actions will take precedence. They will preempt state efforts. And that's with the federal government, encouraging bingo or encouraging gaming. The federal government was preempting states in that respect. Well, in this case, the federal government was encouraging the tribe and probably assisting the tribe through grants and so forth to develop this resource. And the state comes along and says, oh, no, that's our area. And the federal government says, no, we preempted you here. So the other one is the balancing test. Balancing test is basically the court weighing the investment of all sides. So in this, the balancing test of the state versus federal government or state versus the tribe. In a sense, that's why I ask, why in the heck did New Mexico even bring this lawsuit? Because they were only trying to, they're only trying to lay out their, they're trying to get their own licensing fees out of it. Are any of you familiar with the programs that the Cherokee Nation and the Choctaw Nation engaged with the state of Oklahoma with hunting and fishing? They came up with a deal where the tribe would pay for the state license. That's what the way they built it. This was the last chief. What was his name? Bill John Baker. Is that it? Bill John Baker. So he's kind of a good old boy, but he had this deal where he made a deal with the Oklahoma Department of Wildlife Conservation, and it was really a smart thing politically for him, because what he did was they created like this website, and you could, if you wanted the tribe to pay for your hunting and fishing license, all you had to do is send in your social security number, which is kind of ridiculous. You send in a social security number, your name, and maybe your CDIB, copy your CDIB card or something. And so he got his license, and with the license, it was a combination hunting fishing license, and it included one antlered deer tag or deer license, which normally would cost you $10. And then also a turkey tag, which I think would also cost you about $10 or something like that. Okay, well, it's not a lot of money, but essentially the tribe was handing out something that would generally cost someone probably around $40, $50 altogether. Okay, now I know that's not a lot of money to you all, but I thought it was pretty significant. Now, interestingly, it was kind of a win-win situation for the tribe and the state. I thought it was pretty fascinating. The state won and the tribe won. Now, Bill John Baker won because he got lots of brownie points by buying tribal members' hunting and fishing license for a year. Now, it only worked for a year, and they did it for that 2 or 3, 4 years. So he got his political capital out of it, and the state of Oklahoma got a good deal because it increased the number, or was slated to increase the number of people holding hunting and fishing licenses within the state. Now, I think the way that it worked was the state of Oklahoma making a deal with the tribe gave the tribe a discount. So let's say that the state allowed the tribe to pay 1/2 of what the actual price was. Okay, but the increase in the number of people holding licenses, that was kind of a gold mine for the state. Well, not a gold mine, but it was advantageous to the state, because the state, through a couple of federal laws passed a long time ago, the Dingell-Johnson Act and others, the state receives federal funds from the sale, basically taxes on the sale of hunting and fishing gear. And that includes firearms and ammunition. And there are big federal excise taxes on firearms and ammunition. states receive a share of those funds based on the number of people who hold hunting and fishing licenses. Okay. So by giving the tribes a discounted hunting and fishing license, they were probably pulling in more than what they were losing, probably a lot more than what they were losing through federal allocations. And they needed those federal funds. So they were, I thought it was a great idea. But I think then what happened was Kevin Stitt came along, that's not what happened. Kevin Stitt, the governor, got into a ruckus with the tribes when he tried to sort of blackmail them for casino profits. Wasn't that the case? I can't remember exactly, but basically the relationship between the tribes and the state has soured, and that is awful because you have contentious things now. It would make a lot more sense for the tribes and the state to cooperate. They could come up with more sorts of deals where the state and the tribe are getting an advantage in some way. But that's all I'll say about that. Okay. So thinking about Mescalero and the fact that the courts recognize the tribe's pretty much exclusive jurisdiction to manage and regulate wildlife and game, hunting and fishing. What does McGirt do to the tribes now? Now the licenses that the Choctaw Nation, and by the way, the Choctaw Nation issued, a combination hunting fishing license, but then they issued like 6 deer tags or something like that and 2 turkey tags. So they were like really, really, generous. But that was before McGirt. That was before those reservations were realized. And the licenses were for anywhere in the state of Oklahoma. They were just state licenses, that's all. Now, can the tribes issue their own licenses and say that the state of Oklahoma does not have concurrent jurisdiction over Indian country?
Now, and then after the question now, since most of our major lakes were done by the Corps of Engineers, by the Federal Corps of Engineers, are they federally owned technically, or are they state owned?
Oh,
So
yeah.
if they're federally owned, then wouldn't that get right in with the tribes, and maybe they could do their own fishing thing off a Grand or Eufaula, or similar to what Mescalero did with the elk.
Yes, I mean but it doesn't have to be. I mean, they've got the reservation now, and since it's Indian country.
Well, see, that's what I was thinking, because don't all the major lakes fall within an Indian reservation?
Yeah, I mean, a lot of them, and not only that, they're federal land. So they're Army Corps of Engineers or Grand River Dam Authority lakes, which is GRDA, I think, is a federal entity. If not, it's I don't know. I think it's like TVA. So
Probably.
Maybe it's a public-private thing.
I've toured the dam, but I can't remember what they said in the tour.
So, okay, so based on what the court said in Mescalero, basically that the state doesn't have the authority just to extend it. What do you think would happen with Oklahoma? I mean, the way I see it is the state kind of blew it for itself. They've basically pissed off the tribes. So what's to stop the tribes from asserting themselves and asserting what they can probably win in court
and undercutting the state in fees?
Yes, exactly. I mean, if you hunt in Creek County, even on private land, then doesn't the tribe have at least concurrent jurisdiction over that private land, just like the state has? The state has jurisdiction over private land, period. All right, and it's going to. Now, whether or not, now there's a case here. Does the state have concurrent jurisdiction over fee land within a reservation? That's Montana versus United States versus Montana. Montana versus United States, right? That's the question. Well, okay, then we'd have to apply the Montana test, right? So you suppose one of the Montana exceptions would apply if the Creek Nation started issuing hunting licenses for hunters, or turkey tags or something like that, or created its own season, or the Cherokee Nation. I used to hunt prairie chickens when I was young, back when prairie chickens were common, and I always went up to Nowata County, to an area that was great to hunt them, but now you don't hunt them. Could the Cherokee Nation issue special habitat regulations for lesser prairie chickens, which are, a threatened species, or a species of concern at least? Yeah, they could do that. Absolutely, I'm guarantee you they could do that. And I hope they do. I hope I hope they create stronger regulations than the state, just to jack with the state. It would be interesting. All right. Well, we've through Castro Huerta, the question of concurrent jurisdiction for criminal law enforcement has been answered. But we're not talking about criminal law enforcement. We're talking about natural resource management. That's a very different thing. What do y'all think?
Well, so my feel on this, because the original question was, how does McGirt change everything? My feeling on it is, like, McGirt was really like resetting the clock and saying, hey, you never disestablished the reservation, so there is a reservation here. So it kind of changes the discussion to just say, like, Oklahoma is now like, Wyoming, or New Mexico.
South Dakota. Yeah, I mean, we're a lot like South Dakota in that we've got some big reservations now that cover large areas and even up in Pine Ridge, Rosebud, those have greatly reduced amounts of actual trust land. There's a little bit of tribal land or tribal trust land, generally where the old agency was, and tribal headquarters. Casinos that have been placed into trust. Casino land has been placed into trust, but generally it's checkerboarded, and there's there's the majority of fee land within the boundaries. But that's essentially what we have in Oklahoma is pretty typical. It's 7:30 and I'm pretty much done talking, but let me show you one last thing before we go, okay? Not sure. All right, I was wanting to show you this map because once you get it loaded, all of that salmon colored shading, those little dots, that indicates trust land. But I thought this was a pretty interesting map because, like you can see how the allotments were chosen along the rivers in the Comanche, Kiowa, Apache, as well as the Cheyenne, Arapaho, and the Wichita, Caddo, but here I am in Stillwater, right there, and I'm surrounded by trust land. It's pretty interesting. I mean, there's a lot of trust land in the Oto and Ponca reservations, or former reservations.
So I know that to get land to go back in trust, they have to file with the federal government and everything. But say like just off the top of my head, the Pioneer woman came into my mind because her husband's family owns a bunch of land.
You know, I know the Osage have had for years, they've had this sort of what they call a repatriation program, repatriation of head rights, right? Because they've lost all these head rights. But I'm not real articulate on how that works. So like the Rosebud, or all of this trust land is former reservation, but it's all trust land now. So anyway, it seems to me that I guess the last comment I'll make here is that the tribes in the state of Oklahoma would be a lot better off if they got along. And you know, it's kind of idiotic if you've read this textbook, if you've been, you know, in this class, it's kind of idiotic for the state to try to throw its weight around, because the state will always lose in you know, in the courts. Not always, but I mean, most of the time they're going to lose. And I don't know why these politicians think otherwise. We have some politicians that are pretty wise when it comes to Indian country. Tom Cole is one. Of course, he's a tribal member, right? But anyway, it would just make a lot more sense. And you know, they used to cooperate quite a bit until this